Imagine saving your family millions of dollars with just one word. Intrigued? Well, stay with me because you're not going to want to miss this. In this video, I'm going to reveal a powerful strategy that could potentially save your family millions of dollars in estate taxes. This is a must-know for every married couple out there. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the Estate Planning Guys. So back in 2019, the Treasury Department issued final regulations that clarified how the federal estate tax exemption works, particularly concerning something called portability. These regulations highlight how a surviving spouse can utilize the unused portion of their deceased spouse's estate tax exemption, and that allows them to ensure that valuable tax benefits are not lost. So I've reviewed these regulations meticulously to provide you with the most accurate and actionable advice. This deep dive into the new rules will help you understand how to effectively use portability to safeguard your family's future. So first, let's talk about the federal estate tax. I know that sounds like a lot of fun, right? When someone dies, their estate can be subject to a really hefty tax of 40%. So back in 2020, the exemption was set at $11.58 million, and it's tied to inflation. So currently, the estate tax exemption is $13.61 million. And this means that if an individual's estate is valued at less than $13.61 million, it is exempt from the federal estate tax. However, the estate tax is applied to any value above that exemption, and it's at a rate of 40%. If you're finding this information helpful, please like this video and subscribe to our channel for more estate planning tips. Now fast forward to 2026, and there's a significant change that's coming that I call the estate tax cliff. The current exemption amount, which is right now $13.61 million, and it's adjusted annually for inflation, is set to sunset. So that means that we're going to revert back to where the law was before this new estate tax scheme came into place. So we're going to revert to the previous threshold amount of $5 million indexed to inflation, and we expect the exemption to be around $6 to $7 million come January 1st, 2026. So that cuts it about in half, maybe a little bit more than in half from where it is now. And that drastic reduction means that many more states will be subject to this 40% federal estate tax. So essentially, an estate valued at $12 million today would owe no estate tax, but in 2026, the taxable portion of that estate would be $6 million. And that results in a $2.4 million tax bill. $2.4 million tax bill. So that's what's going to happen if there's no action at all on the law. Now, we don't know yet who the president is going to be or how Congress will be composed, so things could change, but that's what's set in the law to happen as of December 31st, 2025, and then rolling over into January 1st, 2026. To make sure that you're prepared, check out the link in the description for a free guide on estate planning essentials. We've got a bunch of free resources. We want to make sure that you've got the right plan in place to protect your family. Now, here's the game changer. It's called portability. And this one word can allow a surviving spouse to combine their own exemption with that of their deceased spouse. So that potentially saves millions in taxes. You can effectively double your estate tax exemption. Portability lets the surviving spouse inherit the unused federal estate tax exemption of their deceased spouse. But to take advantage of this, the surviving spouse must file an estate tax return at the time of the first spouse's death, even if no tax is due. So let's assume you've got a $10 million estate, your spouse passes away, there's not going to be any estate tax due, but you should want to preserve the portability of that deceased spouse's exemption. And in order to do that, you have to file an estate tax return within 9 months of their death. No estate tax due, but you file the return to preserve the portability. So let's talk about an example scenario. So, let's say we've got Barry and Pam. Barry dies in 2020 with an estate of around $6 million. Now, They don't need to file an estate tax return for estate tax purposes. Pam's going to inherit everything without any estate tax. And let's assume that the estate grows to $17.58 million by 2026. Without portability, their children could face an estate tax of over $4.63 million. But if Pam elects portability, she files that estate tax return upon Barid's death, then potentially the entire $17.58 million could be exempt from estate tax. So filing the estate tax return and making the portability election allows Pam to utilize Barid's unused exemption, effectively doubling her exemption amount and avoiding millions in estate taxes. $4.63 million. So to sum up, understanding and utilizing portability can significantly reduce your family's estate tax burden. And don't assume that your lawyer will automatically handle this. Be proactive. If your attorney's not talking to you about portability and filing the estate tax return, you need to ask the question, should we do this? That's the only way you can preserve that unused exemption so that your kids can use that potentially when you pass away. For more estate planning tips and strategies, check out our next video. And don't forget to subscribe and hit the notification bell so you never miss an update. I'm Mike Smith with the Estate Planning Guys.